In this short video, I will explain some basics of consumer bankruptcy. More specifically, I will talk about important bankruptcy terms, the two types of consumer bankruptcy, debts which cannot be discharged through bankruptcy, and mandatory consumer counseling. Bankruptcy is a legal procedure that provides relief or protection from repaying debts and creditor harassment. Before I get into the discussion, I'll define a few important terms. Debtor. A debtor is the individual who owes money and is in debt. Creditor or lender. The company or individual that debt is owed to. Discharge of debt. After discharge of debt, a debtor does not have personal liability to pay specific debts. Exempt property. Exempt property is protected from creditors and is not liquidated in the bankruptcy process. Exempt property varies depending on state law. However, in most states, exempt property includes a car, clothing, tools used for work, and household items. Secured debt. Secured debt finances the purchase of property. Examples of secured debt are mortgages or car loans. If a debtor fails to pay their mortgage or car loan, the lender may foreclose on the mortgage or repossess the car. Deficiency judgments are entered when a secured debt is worth more than the repossessed or secured property. Deficiency judgments are dischargeable through bankruptcy. There are two types of consumer bankruptcy. Chapter 7 is called liquidation bankruptcy, and Chapter 13 is referred to as wage earner repayment plan. The court uses a means test to determine which debtors are eligible for Chapter 7 and which debtors should be filed under Chapter 13. With Chapter 7, the debtor's non-exempt assets are liquidated and distributed to creditors. After the process is complete, debts are discharged. Chapter 7 can only be done once every 8 years and shows up on the credit for 10. With Chapter 13, the debtor organizes their debts into a repayment plan, which lasts 3 to 5 years. The debtor is supervised by the court when organizing the repayment plan. Chapter 13 allows the debtor to keep most non-exempt property and would be liquidated under Chapter 7. Debts are discharged after the repayment plan is completed. Chapter 13 should not be filed again for 4 years and shows up on the credit for 7 years. Both types of bankruptcy are effective ways to stop creditor harassment, collections activity, and wage garnishment. After filing for bankruptcy, an automatic stay halts actions by creditors, with certain exceptions. If you are considering bankruptcy because of a mortgage debt, tread with caution. If you want to save your home, bankruptcy will often complicate the loan modification process. Bankruptcy does not discharge mortgage debts. The debtor will still face the threat of foreclosure if mortgage payments are not made on time. Both types of bankruptcies have been used to stall foreclosures. To get specific information about how bankruptcies can be used to stall foreclosures, speak to a bankruptcy attorney. Neither type of bankruptcy discharges all debt. You will still be liable for some student loans, taxes, alimony, child support, certain fines and penalties owed to the state, income tax, and recent property taxes.